Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in George versus McDonough, Secretary of Veterans Affairs, certiorari to the United States Court of Appeals for the Federal Circuit, argued April 19th, 2022, decided June 15th, 2022. If you'd like to support the podcast, find the PayPal link in the show notes. When petitioner Kevin George joined the Marine Corps in 1975, he did not disclose his history of schizophrenic episodes. In a medical examination noted no mental disorders. After George suffered an episode during training, the Marines medically discharged him. George then applied to the Department of Veterans Affairs under 38 U.S.C. Section 1110 for veterans' disability benefits based on his schizophrenia. A regional office of the VA denied George's claim, and the VA's Board of Veterans' Appeals denied his appeal in 1977. In 2014, George asked the board to revise its final decision. When the VA denies a benefits claim, that decision generally becomes final and conclusive and may not be reviewed by any other official or by any court after the veteran exhausts the opportunity for direct appeal. See Section 511A or Section 7104A. But George sought collateral review under a statutory exception, allowing a veteran to seek revision of a final benefits decision at any time on grounds of clear and unmistakable error. Sections 5109A, 7111, and C38 CFR sections 3.105, 20.1400, 20.1411. In particular, he claimed that the board clearly and unmistakably erred by applying a later invalidated regulation to deny his claim for benefits without holding the VA to its burden of proof to rebut the statutory presumption that he was in sound condition when he entered the service. The board denied George's claim for collateral relief, and the Veterans Court affirmed. The Federal Circuit also affirmed, concluding that the application of a later invalidated regulation does not fall into the narrow category of clear and unmistakable error, permitting revision of a final decision under 38 U.S.C. sections 5109A and 7111. The Supreme Court holds. Decision is affirmed. Justice Barrett delivered the opinion. The invalidation of a VA regulation after a veteran's benefits decision becomes final, cannot support a claim for collateral relief based on clear and unmistakable error. This case turns on the meaning of the 1997 statute subjecting a final veteran's benefits decision to collateral review on grounds of clear and unmistakable error. That's 111 statute 220 or 2271 at 38 U.S.C. section 5109A and 7111. No statute defines the term clear and unmistakable error, but the modifiers clear and unmistakable, as well as the statutory structure, suggest a narrow category. A robust regulatory backdrop fills in the details. Where Congress employs a term of art, obviously transplanted from another legal source, it brings the old soil with it. See, for example, Taggart versus Lorenzen. That principle applies here. The court agrees with the Federal Circuit that that Congress codified and adopted the clear and unmistakable error doctrine as it had developed under decades of prior agency practice. Cook versus Principi. That was in bank of. That history reveals that this category of error does not encompass a subsequent change in law or a change in interpretation of law, and the invalidation of a prior regulation constitutes a change in interpretation of law under historical agency practice. Defined by this regulatory history, the statutory term clear and unmistakable error does not encompass claim like George's. In response, George argues that the VA has distorted the history of agency practice that the 1997 statute codified, but across a century of review for clear and unmistakable error, George can muster only one uncertain outlier case sustaining a claim that arguably resembles his. which does not move the mountain of contrary regulatory authority. He alternatively argues that the VA is wrong to call a later decision invalidating a regulation a change in interpretation of law, but that it is a perfectly natural use of language. But that is a perfectly natural use of language. George tries to bolster his position by invoking cases explaining that a judicial decision states what the statute always meant, Rivers versus Roadway Express, and an unauthorized regulation is a nullity, Dixon versus United States. But those general principles do not disturb the conclusion that the board's application of a then binding regulation is not the kind of clear and unmistakable error for which collateral relief is available under sections 5109A and 7111. And that longstanding VA approach is consistent with the general rule that the new interpretation of a statute can only retroactively affect decisions still open on direct review. George also leans on what he describes as the plain meaning of the words, clear and unmistakable error. But as he concedes elsewhere, the real question is not what might be called clear and unmistakable error in the abstract, but what the prevailing understanding of this term of art was when Congress codified it. The fact that Congress did not expressly enact the specific regulatory principle barring collateral relief for subsequent changes in interpretation does not mean that the principle did not carry over to the statute. Statutory silence on the details of prior regulatory practice indicates that Congress left the matter where it was, pre-codification. That's Cusiana versus Holder. Decision below is affirmed, and Justice Barrett delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas Alito, Kagan, and Kavanaugh joined. Justice Sotomayor filed a dissenting opinion in which, and Justice Gorsuch filed a dissenting opinion in which Justice Breyer joined, and in which Justice Sotomayor joined as to all but Part 2C. Thanks for listening. If you'd like to support the podcast, find the PayPal link in the show notes.